We hear about boards hiring and firing CEOs all the time. But how does that actually work, especially when executives are often on those same boards? The 2007 Delaware case of Fogel versus U.S. Energy Systems Incorporated fleshes out one such scenario. In 2005, U.S. Energy, a publicly traded energy production company, hired Asher Fogel to serve as CEO and sit on its board. The board was comprised of Fogel as chairperson and three others. At a June 2007 board meeting, at which the other three directors learned of the financial challenges facing the company, the board resolved to hire a professional to help. At the same meeting, the board also resolved to meet on June 29th to interview potential candidates. On June 29th, prior to the scheduled meeting, the other three directors agreed that they had lost confidence in Fogel and decided to fire him. They proceeded to the boardroom and shared the news with Fogel, requesting he resign before the end of the day or face termination. Fogel challenged the validity of the decision and left. Before the end of the day, one of the directors called Fogel and told him he was terminated. On July 1st, Fogel emailed the directors, calling for a special meeting of the shareholders to remove and replace the other three directors. Doing so was within the authority of the CEO and chairperson. The other directors ignored Fogel's request for a special meeting. A regularly scheduled board meeting was also held later that same day, at which the board formally resolved to fire Fogel. Fogel sued the directors in trial court, claiming that any special board meeting deciding his termination prior to July 1st was improper and thus invalid. Fogel contended he was still chairperson when he called a special meeting. Fogel petitioned the court for a declaratory judgment ordering the special meeting to still be held.